Hello everyone, this is Rajiv. Today is September 12th, 2013. This is our conference call, community conference call that we do every 2 weeks. As you would have heard when you logged in, this call is merely for informational purposes, nothing more, nothing less. We had a malicious attack on forums 3 days ago. And so we lost some data and we rebuilt it. We are updating the software. We are updating some of the security measures. It's a silly thing to do. People take a strange pleasure. I mean, we are not NSA or any extremely high security site that you cannot break into. I don't know where the pleasure is. Anyhow, this is what somebody wants to do. I guess that's the way it goes. So that said, let me get started with the questions. Jeff Korn has posted. Now this is an old member. I see right now we can't even tell how many posts he made. Normally this is the area where we can tell how many posts. That data is still being rebuilt. So anyhow, I remember his name. He's been around for a long time. So here's some questions about N400. Remember guys, I can never help you fill forms. I can give you general advice, but I can never help you fill forms. So I'll do the best I can giving generic advice. When you fill in the N400, there is a question there about memberships in associations. Okay, so he said that initially when he filed 485 also, this question was there. They didn't answer it. Later on, they amended the 485 and answered this question. Or it doesn't matter. Basically, they did mail it in. So the question is now in N400, how do we deal with it? I am always inclined to over-disclose. So whatever you can think of, whatever association, etc., you can think of, organization's name, etc., just go ahead and give it to the best of your ability. As full as you can make it. By the way, this question used to be a lot more relevant during the times when we used to consider membership in a communist party as grounds for exclusion. That time is gone. Now we are looking, I guess, at terrorist organizations. So the question has become relevant again. Really, that's what the most focus is. Nevertheless, you should go ahead and disclose it all. Okay, I personally feel every organization, including faith-based organizations, should be disclosed. Question number 2, how do you disclose traffic tickets? There was recently a meeting minutes that I was reading with, I think it was Detroit, Detroit area field office, and the same question was asked, do we have to disclose traffic violations? And they said yes. If there is any citation, you should, a speeding ticket, etc., all of these should be disclosed. Okay, so you should always disclose, and whatever the outcome is, if first ticket was disclosed, or you're saying some were dismissed, what you can always do, Jeff, is you can add a letter or an addendum to the form that explains all your tickets. Disclose them all as best as you can remember, and if there is more than the ones that you can remember, just make a note that there may be others but you don't remember them all. Okay, hopefully that will take care of it. I personally err on the side of over disclosure. Same for your question number 3, other names used, disclose them all. Don't keep anything back. And your question number 4 is, what if I miss something or fill up something incorrectly, inadvertently? Then what happens? If I made a mistake, that's okay. You don't have to be perfect, but you have to try to be as accurate as possible. Just make sure of that. Don't get nervous about it, but be careful. Okay. Next question, Fennel C4, H1B transfer and green card. So currently on H1B, green card applied in EB2, I-140 approved, 6th year ending this month, September 30th. Client is offering a job. They're going to do the green card again. Immigration lawyer says we need to start the process again. That is true, because unless your 485 has been pending 180 days, you will have to restart the process. Okay. Real quickly, I want to make sure everybody can hear me. Let me just double check.
The conference is now in conversation mode.
Can everyone hear me, folks? Is my voice clear?
Yes. Yeah.
Excellent.
Yes, we can.
Excellent. Let me get back to it.
We can hear you.
Yeah, let me get back to it.
The conference is now in presentation mode.
Okay. It has happened to me once. I did an entire conference not realizing that there was something wrong with the software and they couldn't hear me. So it was an odd situation. It's happened only once in 10 years, but it did happen. Okay, so now I'm moving over to the client. I have to start all over again. Would I be able to retain my priority date? Absolutely. Absolutely. How risky is it to change the employers? Look, I don't think there is a great amount of risk. The only thing I would be careful about is you can do a 3-year H1 extension based upon the approval from the current employer onto the H1 of the future employer. So do a 3-year extension, do it premium, don't join the client until the H1 extension is approved. That's the only thing I would be careful about. Once you get 3 years of H1, I think that's sufficient time for you to start a new POM, etc. I don't think it's overly risky. If you like the job, I would do it. Is it advisable to change? Yeah, I think so. If the current immigration reform passes in near future with merit-based system, well, first of all, merit-based system is an addition. It's an addition. Even under S744, it is not a substitution. So that gives you additional options. It doesn't take away the existing options. Also, Boehner from the House of Representatives said that we are probably going to see the Republicans vote on their version of immigration law. Skills bill is one of them, which has a totally different set, or at least quite different set of provisions as compared to S744. In some ways it is not as good as S744, which is the Senate version, or in some ways it is better. So there are differences in that bill. What happens is, if House passes their version and Senate has its version outstanding as it does, they'll have to come together in conference. Senate will negotiate with House, and then they'll come up with a joint version. Okay, so we don't know what the future will be. It's too early to talk about it. Next question, Oxelar 8. Oxelar 8 says, country of birth is India, but I'm an Australian citizen with E3 visa. I have approved I-140, current E3 is expiring. Employer is ready to file extension after his research. They thought that E3 will not be approved because I-140 is approved. That's not true. E3 can be approved. Shouldn't be a problem. My husband has L1A visa. I applied for L2 as dependent few days back. Husband's company is also filing EB1. That's very good. Do you think it's a good idea to apply for E3 as well? Why? You've got an L2 going, you'll get your EAD. But if you want to, you can. I don't see any problem with it. If in case L2 comes first and somehow E3 gets denied, what status will I have? You should have an L2. Okay. Also, can I stay legally in US while L2 decision is pending? Yes, as long as you file, your E3 is not expired yet. It's expiring in a month. So you have enough time. Yeah, you can apply for an L2. You can do it online actually if you want. The advantage of doing online is it gets there the same day. It gets there right away. Then she says, can I stay legally while the L2 decision is pending? Definitely. How can I get a driver's license? That's a state law issue. I really cannot comment about that. Every state has its own little nooks and crannies in which they put these various areas of the law. I will apply EAD next week once I have the L2 receipt. Do you think there's any issue applying EAD with L2 receipt? No, I don't think so. I don't think so. Double check it with the USCIS. I don't know. I'm pretty sure the procedure that we follow in my office, we actually file the L2 and the EAD at the same time. I could be wrong about this, but I think I had a conversation with Anna who's the supervisor of our non-immigrant visa section. I think she mentioned that to me, that we are doing both at the same time. My son is turning 21 on 22nd October. Will he be safe? See, here is the problem. The only time you can take out from his age is the time during which the I-140 is pending. So as long as you get I-140 485 filed before he turns 21, or using the subtraction formula, he is below 21 the date you file his 485, you should be safe. Okay. Question about wife petitioning family from the Philippines. Okay, now the question is this. Joe 808 says, I remember reading this about an hour ago. So the question was, when my wife, who's become a citizen, applies for her mom, do the minor children of the mom, which is her brother and sister, also get green card with her? No. No. Here is the difference. Immediate relatives, which is mom, dad, and spouse, and minor children, etc. When you apply for your mom and dad, the good news is they are not subject to any quota, so they come right away. But the bad news is their derivatives cannot inherit that benefit. So mom and dad would have to apply for their children separately. Of course, you can apply for your brother and sister separately. So once again, when your wife applies for her mother's minor children are not included. Next question is from Vikram, who is VKong001, I-140 H1B transfer. Guys, what I'll do is, I know that because of this screw up with the forums, we were not able to get everybody's questions. So what I'll do is, once I'm done answering these questions that were posted, I will lock the conference and make sure nobody else comes in, but I will answer the questions of everybody who's logged in. So we won't, we won't lose any time for you guys. Okay, now I-140 H1B transfer from Vikram. H1B visa 4 years, and I have an approved I-140 with priority date of March 2012 in EB2. Planning to change jobs. Questions are, what will my current employer have to do to keep the I-140 active? They have to do nothing. They have to do nothing. The I-140 stays active even if you leave, but here is the problem. You see, if the employer has multiple green cards going, having an I-140 active for somebody who has left becomes a problem, because they have to establish the ability to pay wages for all green card cases. So if there's 5 green card cases, and let's say your salary was $100,000, you left, employer still has to prove the ability to pay that $100,000. If they revoke your case, then they don't have to prove that. It makes it easier for them to process their other green card cases. So some employers might find this problematic, some others don't. Okay, so is the employer saying that they have to pay taxes, they have to show profit? To some extent they are right, but they can also show it as net current assets and not pay taxes. That's something they can figure out with their CPA. It's perfectly legal to do that. Okay, so yeah, to some extent your employer is right, but they can try doing an analysis of their Schedule L net current assets. If my current employer agrees to keep the current I-140 active and the client also applies for a green card, can I use the old PD? The PD can be used even if the current employer revokes the I-140. The only thing you will lose is the right to continued H-1 extensions based upon an I-140 that has been revoked. But otherwise, the only way you lose your priority date, your PD, is if the I-140 is revoked for fraud or misrepresentation by USCIS. 3, can I have both H-1Bs active with client and consultancy? You can, only doing part-time, but you'll have to amend that H-1 if you want to go to part-time. Do you see anytime soon the priority dates moving? I don't know the answer to that question. Anybody's guess is good enough. K3 visa, NICAT says, what is the process of getting a K3 visa spouse in India? I'm waiting for N400 application to go through. I think you should apply for I-130 now. I don't see any problem. And then apply for K3 once the I-130 receipt comes and your N400 comes. That way, whichever comes first, her green card or her K3, she'll get that first. Remember that if consulate receives notification that her green card is already approved, I-130 is already approved, they won't issue K3. They'll ask her to wait for the green card, which is okay, which is not the end of the world. Ma1 says EB2 green card process and H1B extension. Okay, let me see if I can understand this. Priority date is November 2009 under EB2. I-140 approved from previous employer in October 2010. Resigned from that employer. Joined the current employer from November 2010. Based on the company lawyers association, 100% association that my case, assurance that my case will be refiled from current employer under EB2. Oh yeah, I remember your case. So you have a BTEC, which is, I assume it's a 4-year degree, mechanical engineering with specialization in manufacturing. And you are a DBA, and you have experience since, you have 15 years of experience from the date of graduation, which is, I think you can file an EB2. I don't see why not. Okay. I have noticed, if you look at our website, if you go to immigration.com, in the sample cases, I just made a note yesterday. Department of Labor had denied a whole series of firms for, I think, hundreds of law firms, saying that when you require a degree in engineering as acceptable, that is too vast, too wide. So we are denying, because sometimes like degrees like agricultural engineering are not really qualifying you for agricultural jobs. IT jobs. So when they denied 2 of our cases, we had a consultation with the clients, and I was firmly of the opinion that they are wrong. I was willing to litigate this case. I was going to take it to federal court if necessary. So we filed an MTR on these 2 cases, and the brief was very, very large. I think almost a 100-page brief. A lot of evidence showing that their entire approach to this problem was wrong, and that there is no requirement in the law that we have to be mathematically accurate. We have to be reasonably accurate. So we are saying we'll accept a degree in engineering. Any branch of engineering can work when it is combined with the right amount of experience. So Department of Labor did approve those cases, so they backed off one of the cases. I'm sure they'll do the other one too. So, the reason I know it's a countrywide problem is because I was asked for a second opinion by employers who were being represented by other law firms also. And I know that American Immigration Lawyers Association was also trying to get the Department of Labor to back off. But in any case, they have backed off. I personally don't see why you cannot do an EB2. And nothing has changed in the last 3 years that I know of. Go for EB2, I think. As long as the job requires a degree plus 5 years, you can go for EB2. If I have an approved I-140 from previous employer, I will be entitled to get infinite years of H-1B extensions. That's correct. Even if you have changed employer, that is correct. And PERM has not been filed. You can still file PERM, and that will not interfere with your right to get H-1s based upon the old I-140, as long as that I-140 is not revoked or withdrawn. Question number 4, can an approved I-140 be revoked? Yes. By the employer or by USCIS. How can it impact me? It only impacts you for further H-1 extensions. They will not take away your current H-1 extension if the I-140 based upon which you got the extension was revoked. But you will not be able to get further extensions, and it does not disturb your priority date. Okay, yeah, Sean, go for EB2. I don't see any problem with it. Next question, number 9, is from IMQ7. In 2008, employer A1 filed for an H-1B, which was approved, valid till September 2011, but I did not get it stamped. Then B2 filed for an L1, and I'm working on L1. They don't want to do my green card. Now, company C3 is willing to file both my H-1B and green card. I understand that my new employer C3 can file for a quota exempt H-1B. I think so. Since 6 years have not passed, I think it's 6 years from the date of approval of the H-1. I haven't looked at the law specifically for this issue, but in the back of my mind, from what I remember, it should be 6 years from the date the H-1B was approved, which is the start date of the H-1B, October 1st, 2014. Okay, that's what I think it would be. Oh, actually, by 2014. Your H-1B was approved in 2008, so it will go back to 2008. 2008. One interesting question would be, how many years of H-1B can you get? And I think you should be able to get 3 years, at least. Okay, so double check that. It's a little bit complicated issue that has to be worked out, but it is clear to me that you should be able to get H-1, and you should be able to, and this part is not clear, but I think it should be 3 years. Okay. You have to, of course, subtract the L1 time from it. So 2010 you got L1, that's 3 years of L1. But you never came to the United States before that. So if we use the remainder option, would you get 3 years or 0 years because of the L1? Not quite sure about it. Definitely worth a shot though. Okay, I'm not sure. I'll have to look up the law to figure out the details, because this has some interesting issues. One issue is, okay, so you are entitled to your H-1 exemption, but then you are only entitled to remainder. What remains of your H-1? What remains is 3 years after 2011. But then you have 3 years of L1 already. Would that cause a problem? I'm not sure. I'll have to look it up. But definitely I can see some issues here. Sandeep says L1A to H1B transfer on exempt quota. Working in USA with company A on L1A since 2012. Well, first of all, you should get your green card through company A, because the EB1 green card is so much quicker. Within a year you get it. Okay. So really there is nothing else to discuss. You should go for, oh, they're not willing to start your green card process. I see. Okay, let's look at the rest of the issue. Working in US with company A and L1A since August 2012. L1 is valid till 2015. Prior to that, you had an H-1B from company B in November 2011. But you didn't use it. You didn't join that company. Cancel stamp was put on H-1B. Then you got your L1A. Company C is giving you an offer. They want you to join by the first week of December. I think you are eligible to receive H-1B quota free because you had an H-1B in the last 6 years. Your problem is similar to the problem of the gentleman I was talking about a minute earlier. That, okay, so you are entitled to at least 3 years of H1, out of which will they take out the L1 time? That still leaves you enough time. If the green card is started, because you have been on L1 only for a year. So at least 2 years of H1 you should be able to get. Maybe more. I would have to look up the law and kind of make an argument for it. But there are some issues here. But in your case, I think 2 years of H1 will be enough. Get your green card filed and you can keep getting H1 extensions after that. Okay. Can employer C transfer my existing L1A to H1B? Yes. Under quota exempt? Yes. Can employer C transfer my H1B visa from employer B? Same idea. It's not a transfer, it will be a transfer from L1A based upon approval of employer B. So don't worry about the logistics. Can employer C immediately file 485 under EB1? No. EB1 can only be filed by an employer who is a part of the L1A group of companies. Okay? When you're talking about international manager or executive category, the EB1C or EB13 can only be filed by an employer who's a part of the group of the companies for which you used to work outside USA. Any faster options? If you're in love with a US citizen, yeah, that's the only one. Osbury, my first time here, I'm an American citizen, just married a Canadian citizen. You have to be careful with this. So she's entered USA. At the border, patrol officer asked her why is she visiting. She stated she's going to visit. Nothing else was asked. Original plan was for her to come visit while I get the I-130 process. Then a non-profit organization gave you the idea to file I-485. Please don't. That's very poor advice, in my opinion. I'll give you an example. We have a case which we are struggling with, and these people have been charged thousands of dollars in attorney's fees. Husband and wife, well, they were boyfriend and girlfriend at the time, or fiancé. They enter USA. He's a US citizen. She is not. They enter on a visa waiver, sort of like Canadian style entry. And 3 days or 10 days later, they get married and apply for they were not going to apply for 485, but somebody told them, oh yeah, do 485. Well, they did it. When they went for 485 interview, the USCIS officer said, you have committed fraud because when you entered using visa waiver, you represented that you were going for a visit. In fact, your intention was to get married and apply for a green card. So a really easy case becomes a pain in the behind. All of a sudden, we are now fighting fraud, which is a permanent bar from entering USA. And the waiver that we can get is a hardship waiver. We have to demonstrate that if she's asked to leave, you would have some exceptional hardship. Short answer, do not do this. Do not do this. The right thing to do is let her go back, file for her I-130. If you're married, file for, you're already married, of course. File for her I-130 K3, combo. I think you have to wait for the receipt. Double check that. File I-130, file K3, whatever comes first, she comes using that. Don't do an AOS. Don't do 485. Very bad idea. Next question. Just a question. Jobs change during green card. This is number 12. EB2 in India is now current. I'm expecting my green card anytime. Now getting a new job offer. Same or similar. So what happens if I change? No problem. I actually had a case a couple of weeks ago. Somebody did a consultation with me. And their case was they were working for a consulting company. And I think they were working at Freddie Mac or Fannie Mae. Okay. So exactly your situation. Very close to getting the green card approval. Just before getting green card approval, they joined Freddie Mac, which was the client, directly. Similar job. They called me 5 years ago. What should I do? I said, just make sure you have some evidence, like a job description, that shows these two jobs are similar, same or similar. So that if it becomes an issue at the citizenship stage, we can produce that evidence showing that they are same or similar jobs. Lo and behold, he applied for naturalization 5 years later, again did a consultation with me a couple of days before his N400 interview. Was nervous. I said, don't be nervous, this is perfectly legal. You joined the client a few days before you, or 2 months before you got green card approval, and you never went back to work for the sponsoring company. I think it's fine. Okay. So anyhow, he went for the interview and he says they didn't even ask any question about it. And he got his naturalization. He's all set. Okay. So if I get the job offer before my 485 is approved and join, negative impact during naturalization, I don't see any. If I get job offer after 485 is approved, before I receive the physical green card, I see that becomes a little bit different question. How soon can I leave? As long as you did not have the intention to leave at the time you received the green card approval, not the physical green card, and later on a job developed which is much more attractive for you, I think it's okay to take it, even if it is a month or 2 months after your green card approval. Okay. Number 13 is the Smatian. My wife's sperm petition was filed 1.5 years ago. Audit came. Attorney responded. Filed an H-1B extension. She'll be completing 6 years on September 11th. We got a denial notice. Oh no. Problem with the job ad. Our attorney suggested appealing. Definitely. Appeal might take 1 to 2 years. No, it's closer to 3.5 years. Is my wife out of status beginning September 12th? Yes, she is. What the lawyers should do is they should file the H1 extension and represent to the government that an appeal is being filed. Okay. And you can file an appeal as well as ask for time extension based upon time spent out of the country. Could you help us take care of the situation? Well, look, of course we can. That's what we do for a living. But you already have a lawyer and they have all the paperwork. Let them file the appeal. Let them, if they don't feel like filing the H1 extension, we can do it for you. But it should have been filed already. Okay, because September 11th, today is September 12th. If we do it, it might come to the situation where she'll have to step outside USA to get a visa stamping because she's currently out of status. They should have already filed it. I don't know why they didn't do it. Nevertheless, let them file the appeal because the appeal is not going to be won. I mean, most of these are not, appeals are difficult to win. But we can do the new PERM filing if you want. So we'll be happy to help you. You can send me an email to help@immigration.com, HELP, help@immigration.com. Next question is, Soulu, petitioner died after I-130 approval. And the problem is they don't have any immediate relative. By no means am I an expert on this particular issue. But humanitarian reinstatement is not possible, as far as I know, if you don't have a relative who can step in. Okay. Can you file an e-visa as an entrepreneur? Absolutely. If you qualify, you can. E-visa does not get hurt drastically by a green card filing, so you can. And the last posted question today is the question number 15. Let me make sure I didn't miss anything. No, I did not. 15 is moving to another employer post I-140 approval. Okay. Working for employer X, came for visa stamping, That went into admin processing. In the meanwhile, I-140 has been approved with employer X. After 16 months, I received my visa, but in the meantime started working for employer Y. Y is willing to transfer my visa and transfer me to the US. I think in your case, it's okay. I had actually a client with a similar situation. Their case was different only to the extent that they were not already working for employer Y in India. So in his case, I told him not to change employers. It can hurt his green card. In your case, USCIS and consulate created this problem. So if you change employers and come to USA with employer Y, and eventually still have the intention of joining employer X, your green card can go on. So can the green card still go on? Yes, it can. If I continue working with Y, at what stage do I have to start reworking? You have to have the intention to join them, but you have to join them only after green card approval. And actually that also you may not have to join. After 180 days of 485 pendency, you can choose not to join the future employer as long as you have a same or similar job somewhere else. So obviously you can file 485 with employer X while you're working with employer Y. It's fairly straightforward in most of these cases. Okay, I'm done with my posted questions. What I'll do is, let me ask you guys, anyone who has a follow-up question on the posted questions, please press *3. Before I do that, give me 1 second.
The conference is now locked.
I've locked the conference, so I'll only be answering questions from people who are already on the call. No new callers who log in later. So any follow-up questions on what we have discussed? No new questions. Follow-up questions, press *3. Press *3. Any follow-up questions? Press *3 on your telephone. Okay, I don't see any follow-up questions. Any new questions, any questions at all, press *3. Either I am doing something wrong or you folks really don't have any more questions. Press *3. Well, maybe I'm wrong. Maybe it's *5. Hang on 1 second, guys. Let me confirm. Let me go back. Yeah, it is *5. Okay, because somebody just raised their hand. Okay, it is *5. Yeah, now I see a bunch of questions. So I'm doing something wrong. It's not *3. *5 for any questions. I think I screwed up. Oh, 7, 8. Oh no. Okay, I'll just do all the questions in order. We only have 7 questions, all kind of mixed follow-ups as well as new questions. 8. Please raise your hands now. I won't do any new ones after that. 9 raised hands. 9 people have questions. 8, 7. Okay, 2 people have put their hands down. Hand up again. Now back to 9. Okay, 9. I'll start in the order you guys logged in. Okay. So California, area code 408, San Jose. Go ahead, please.
Hello. Question is, my son is turning 21. Question number 4.
Okay.
And you said that he will age out when the calculation has to be done.
Right.
But because it is the EB1 category, which is current, will the age out thing still apply?
That's a good question. I didn't think of that. You asked for EB1 category. Do we take out the I-140 time? Yes, we do. As far as I recall, the time that I-140 was pending should still be taken out. Okay, but I have to review the CSPA. It has some very counterintuitive provisions in there. So have it double checked, but I am quite confident that anytime the I-140 is pending should be taken out. If you have a concurrent filing,
so can I call your office later to confirm?
We're going to have somebody research it. It's not something we know off the top of our head. I can tell you that. Have your lawyers do it.
Okay.
Okay. And if they can't do it, then go ahead and let us know. We'll set up a consultation for you.
Okay, one more question, follow-up question.
Yes.
The L2, you said L2 and EAD can be applied online and it becomes approved immediately online, correct?
Not approved. Sorry. If you understood that, that is incorrect. It gets filed immediately.
Oh, okay. So
See,
you get a receipt number.
Yeah, right. Let's say, for example, somebody's status is expiring tomorrow. If they post something today, it will get there after the status has expired. If on the other hand, if they do it online, it's filed right away. Their status is good.
Okay, understood.
Yeah, that's what I meant. Okay.
That's all I have. Thank you.
You're welcome. Good luck.
Thank you.
Okay. Let me go on to the next one. Wilson, North Carolina. Go ahead, please. North Carolina, area code 252.
Rajeev ji, namaskar.
Namaskar ji.
A follow-up question is, this is post number 13.
13.
And question number 1 was, is my wife out of status on today?
Right, because
you said yes.
Her H1, she's completing
Well, her
her
extension has been filed,
Oh, extension is filed already. When was it filed?
right?
When was it?
We have the receipt notice. And
Then
it
there
was
is no
filed,
problem. Then there is no problem. Sorry, I missed that part. In the meantime, we filed an H1B extension. Okay. No. You are right. If her extension is already filed, a timely filed extension gives her the right to stay in the United States and to continue working for up to 240 days. Okay?
Okay.
So no problem.
So what will be the best thing to do? Do the appeal or?
Oh, absolutely.
Extension?
No. Do the appeal. If you don't do the appeal, she will not have any right to extend her H1. Okay? And the way we do it in our offices, we time it so that the appeal stays pending while we start a second green card case, and we withdraw the appeal when we are ready to file the second case in such a manner that we already have enough H1 so that when we file the second case, eventually that will become the basis for getting more H1 extensions. So you can time it, the withdrawal of the appeal and the filing of the second perm, in such a way that H1 is not interrupted.
But see, H1 extension will only be for 1 year.
Remember,
So
you can
we
file
have
and
enough time.
no, you still can do it. Remember, H1 extension can be filed 6 months ahead of time.
Oh, okay.
So let's say you start your second
Right.
perm now. Second perm, ads and all that, it takes 4 or 5 months. You're already 6 months into this H1. You can now file the second H1 extension. As soon as you get it, you're ready to file the second perm. Withdraw the old appeal, file the perm.
All right.
Okay? Let your lawyers worry about the logistics, but it can be done that way.
All right. Thank you.
You're welcome. Good luck.
Thanks.
Okay. 5 more questions to go. Now this one, the ID is blocked, so I don't know who it is. Go ahead.
Hi, I'm calling from out of country.
Yes, sir. Go ahead.
My wife is in the U.S. She has we've had a private consultation also. She has had this part for about 11 years and just renewed it about a year ago. She's not really staying in the U.S. much, or she was studying during a period, so she would go back and forth probably about once a year.
Okay.
And we have filed for my I-130, and they sent me in October last year, which is October 2012. We have received the RFP, we've already answered it, so we're hoping for an approval pretty soon. My question is, she has a couple of she just moved to the U.S. about 3 or 4 months ago permanently, and she has a couple of weddings which are going to start from October, November, December. So is it okay for her to be back in India for those 3 months, or would it not be advisable for her to leave during the I-130 application and my green card application, since she's not lived in the U.S. much?
Okay, well,
In the last 12
there
years?
are a couple of separate issues here. Okay, let me explain to you what the issues are. First of all, if she has stayed away from USA too long, USCIS can actually take away her green card. Okay, so I would have to look at the entire history, and I would have to look at the times outside. So there are two possibilities. Either USCIS is going to accept her green card the way it is, or they are not. Okay. Personally,
She has.
go ahead. Go ahead.
She has been going within the 1 year time frame.
That doesn't matter. That doesn't matter. That doesn't matter. You actually have to live in USA. Just because you keep coming every year for a month, 2 months, or even 4 or 5 months does not help you preserve your green card. Your permanent home has to be in the United States. Okay? So, if I were you, without going into any further details, I would not have her leave USA. That will be tempting fate. Let her stay, you get your green card and come. Don't have her move outside USA for even 1 day. Let her stay where she is. She's made it back, don't let her move. Okay?
Fair enough. Also, one more question. We are trying to. I actually live out of India right now for the last for a long period of time. I stayed in India for about 2 years, from ages 16 to 18. I'm supposed to file a police report for the country which I'm a citizen of, but also do I have to file a police report for India also?
I do not know. This level of detail of how many police reports you have to file and where. That's somebody else in our office. A bunch of other people handle those things. I am more the ideas guy, the law guy, not so much the logistics guy. What you can do is, now you are filing through consular processing, right? You are going to the consulate for interview, right?
Yes.
Okay. You can send an email to the consulate. They will be only too happy to tell you.
Okay.
And by the way, that's one thing I must give consulates credit for. They do respond to emails. Their responses may not always be to the questions that you're asking, but they do respond. And some of this information you will actually be able to find online on their website.
Yes, actually, you mentioned more than 16. Actually, it's a little confusing. More than 16 it should be filed, and more than 18 it should be filed. So I wasn't very sure. So
Yeah, I am not sure about this. Because I don't deal with this level of granularity, this level of detail. Okay.
Okay.
Good luck.
Also, one last question.
Yeah.
She's not working in the U.S. She's studying right now, so she doesn't have tax filed, and she has not really paid taxes in the U.S. while she's never worked over there. Is it okay if we get my sister or my brother-in-law to sponsor us? My sister makes about 70. And
Okay, so your question is when the primary petitioner, which is your wife, does not have enough income because she's a student, can you get a joint sponsor? And the answer is yes, no problem at all.
Can it be a sister? Can it be any family member?
It can be anybody. It doesn't even have to be a family member. It can be anybody who is a green card holder or U.S. citizen. Okay?
Thank you very much.
You're welcome. Good luck. Okay. Let's see. We have 5 more questions. Let's go to New York City. Why would you live in New York? Go ahead, please. New York, area code 212.
Hi, Rajiv. How are you?
Good. How are you?
Good. Couple of questions here, and I'm talking about the post number 3.
Number 3.
And the first question was, and you replied to me, but I little bit got confused as to you suggested advice to file for a 3-year extension, and that was through a current employer or a
No,
new employer?
you see what you will do is, even though your I-140 is approved through current employer,
Mhm.
you can file for 3-year extension through the client based upon the I-140 of the current employer. That's legal.
Okay.
So any I-140 approval will entitle you to 3-year extension
Okay. So this should be through the new employer.
through the new employer, through the client. The
Okay.
only thing I don't
Alright.
want you to do is, I don't want you to join the client until the H1 is actually approved.
Right. Right.
I mean, technically you
I
can
got it.
join as soon as the H1 is received, but
Right,
you
right.
should not until it's actually approved.
Sure. Okay. I'll do that. Couple of more questions. So one of the question was if in this process, like this process could take probably an year for me to get the form and I-140 approved again. And in that phase, if a priority date gets current, are there any options left for me?
Yeah, you could file a 485 through the old employer if you have the intention to join them back upon receipt of the green card. And once the 485 is pending for 180 days, you actually don't have to join them.
Okay.
That's a very odd law, but the intention at the time of the filing of the 485 has to be honest. I am going to join them.
Right. Right. But I mean, this is only applicable if they don't revoke my I-140.
Absolutely. If they revoke the I-140, then the I-140 will have to be refiled.
Right. Right. I got it. Got it.
Okay.
The last one was, and this is my current understanding, and correct me if I'm wrong, that my I-140, my priority date remains with me, even if my employer revokes I-140. But that is only if my new employer starts my green card process before the old employer revokes.
That is incorrect. First part of it is correct.
Okay.
Once your I-140 is approved, the priority date is yours. You could, under the current scheme of laws, you could be gone from USA for 20 years and 20 years later apply for a green card again. Your priority date will be the old I-140 approval.
Oh, okay.
Okay?
All right. Okay.
Good luck.
Thank you very much.
Oh,
for your
you're
time.
welcome. You're welcome. Good luck, sir. Four more questions. Nashville, Tennessee.
Yeah, Rajesh ji, good afternoon.
Good afternoon, sir.
Yeah, my question is question number 10.
Number
The
10.
conversion from L1 to H1B.
Right.
So,
Interesting situation.
Yeah, so as I mentioned, I got the H1B from the employer B, but I didn't join.
Mhm.
And when I got the L1 stamping, at that time, in the
They
company
cancelled.
office,
Yeah, they cancelled.
Stamp was,
That doesn't matter.
and the date on that H1B which was stamped was 31st October 2013. It was valid till that date. So when my new employer gives me files for the extension or the transfer, will he have to file before 31st October or he can file it afterwards also?
When was that H1B approved? Remind me.
So the 797 notice of action was received in November of 2011.
So as long as they do it by 2017, I think they can file anytime, no problem.
Okay, anytime within the period of 6 years. That's
Yep,
what you
6 years from the date of the approval. That's what I think
Okay.
it is. Okay.
Okay, I got it. But I do not know whether the employer who has earlier given me H1, whether it has been revoked or not.
That doesn't
How
matter.
to take it?
That doesn't matter.
It doesn't matter.
No. Even if they revoked it, I believe you're entitled to your exemption, quota exemption.
Okay. And the last option is, can I also approach the employer B who has given me earlier H1 to file for my green card through I-485 filing?
Did they do an I-140 approval already?
I don't know. I want
No, you haven't done a green card yet. So they'll
No,
have
I
to
haven't.
start the green card from the very beginning. You only done an H1 with them, not a green card.
Yeah.
Yeah, you can join B, C, whoever you want.
No, if I have to, as you were mentioning in some of the other posts, that I can ask my employer B to file for an I-140 and then...
No, but those are the cases where the employer had already started the green card process. Finished one step, finished second step. Now the question is only of third step. You are not even on that path yet.
Yeah.
So no, it doesn't apply
But
to you.
can I...
Oh, can
I
you?
ask them
Okay,
to start for
hang
my
on.
green card process?
Let me understand your question. I think now I understand what you're saying. What you're saying is, can a future employer, whom I have not even joined, start my green card?
Yeah, future employer or the employer B who had given...
It doesn't matter. Any employer, X, Y, Z, B, whether they have your H1 or don't have your H1, can they start my green card? The answer is yes. Green card can be filed by any employer who intends to offer you a job and whom you intend to join anytime before or after the green card is approved.
But I can join them only once they get the extension done first.
What extension?
The H1 extension, because it is valid till 31st October 2030.
You actually have a lot of confusion about H1 and green card. I suggest you read up a little bit more, because remember, H1 is for the job that you'll be doing now.
Yeah.
So whoever you join, you have to have an H1 through them now. But green card can be done through any employer, whether you are working with them or not.
Okay. I've got one more question, because I'm on the L1A, so my labor certification, I assume, would have already been done.
No. L1A requires no labor certification.
Okay, but in the H1B, it requires the labor certification to be done prior.
That is correct. That's why I'm saying you need to read up a lot more. L1A skips labor certification.
Okay, but H1B does have it.
You have to have it in most cases, not all cases. Extraordinarily qualified people, some other people like that, Schedule A people, nurses, physical therapists, they don't have to have a labor certification.
Yeah, because I'm at a vice president level, so whether I was just inquisitive to ask you if the H1B was done without labor certification or with labor certification.
H1B is done with LCA, labor condition application, which is not to be confused with labor certification, a part of the green card process. Totally different things.
Okay.
Don't confuse them. LCA and labor cert or PERM are two different processes. Okay. So your approach would be to join any employer that you like and have them start a green card process for you.
Okay.
But it's a shame that your employer won't do an L1A based green card. That's so much easier.
Yeah, I knew that, because that could have been done within 6 months also, the green card. But because their project is getting terminated in December, that's the reason they do not want to do.
Oh well. Anything else I can help you with?
No, that's it.
Good luck, Sandeep ji.
Yeah, thanks a lot.
Bye-bye. Okay, we've got 3 more questions, guys. Escondido, California, go ahead, please. Escondido, California. Okay. Portland, area code 207.
Yes, hi Rajiv.
Hello.
Hi, good afternoon. My question was number 9.
9. I see it.
Number 9, IMQ7.
Right, I see it.
Rajiv, my follow-up question to what you just mentioned. So it's similar to number 10, but not to confuse here. My H1B was approved in 2008, and 2010 I entered to work in the US on L1.
Right, I see that.
and I never got my H1 stamped or anything like that.
That doesn't
And I
matter.
believe
That,
you
that,
mentioned-
that doesn't matter, ma'am. The fact that you got your H1 approved within the last 6 years should be sufficient. I'm speaking off the top of my head, just from the back of my mind, what I remember the regulation to say. I haven't specifically looked at it. Let your lawyers do it. But I
Okay.
think it should be possible. It shouldn't be a problem.
Sure. So, Rajiv, then considering 2008, my 6 years would complete in 2014, which will be next year, and October being the start date for H1, I would think that my
Don't
H1
get
is
in the
still
don't
valid
don't, don't
until-
get into the math. It's not that simple. Okay, it's not that simple, because even though the H1 was approved for 3 years, the remainder is still 3 years, out of which do you have to take out the L1? We don't know that. And even if you do, how many years of L1, how many years of H1? This is a complicated math. I'm not sure the answer is even available, but at least it's worth a shot. So don't get into the mathematical calculation. There's a lot more to it than appears on the surface.
Okay. Okay. So then one more question was quota exemption. Is that a subjective matter for the officer, or is it
No.
objectively listed?
No. That is absolutely by regulation. It is not their discretion.
So it is regulation, not a discretion, right?
Yes, ma'am.
Okay. Okay. That's about it, Rajiv. Thank you.
You're welcome. Good luck to you.
Thank you, Rajiv.
Bye-bye.
Bye-bye.
Alrighty. Okay, now we have one last question, it looks like. This is Erie, Pennsylvania. Go ahead, please.
Good afternoon. This is Tarek, and I posted my question, but somehow it got removed. So this is a new question.
No problem.
Discussed.
No problem. Go ahead, please.
So here is my details. So currently I'm on H1B. My perm date, priority date is February 2013.
Okay.
We got the audit in last month, so August 2013,
Okay.
which has been declared.
Okay.
And my visa is valid till December 2013. So following are my questions. First thing is that, is it fair to assume that based on current labor certification status, they are processing around August 2012 cases? So my case will take at least another 4 to 5 months to get approved labor certification.
Those are the approximate times if the date is correct. I don't have the times in front of me. But yes, you can extrapolate like that. That is correct.
Okay. The second question is that because with that situation, I'll lose my, I'll not get labor certification before my H1 get expired. So what would be the probable options to get my H1 continued?
Well, you have about a 2-month gap between December and February, right?
Yes.
So first thing you will do is in about 6 months before February, which is what? February, January, December, November, October, September. You can actually file now for an H1 extension that begins from February 2013. Okay?
Okay.
So you will get your H1 extension, but there'll be a gap of 2 months between December of this year and Feb 2014 when your H1 kicks in. That gap can be covered. Are you married and is your wife on H1?
I'm married, but my wife is not on H1. She's on H4.
Okay. So one obvious option would be converting to a tourist visa for 2 months, both you and your wife, and not working during those 2 months, and start working in Feb 2014 again when the H1 will kick in. Some people go back to school. Some people leave USA for 2 months. While you're outside USA, you can still continue working with the same employer. They can pay you in USA or they can pay you in India. They can pay you on W-2 or 1099.